The safeguards that are available for individuals in relation to the various powers within the bill are various. First of all, there are the authorisation procedures, and obviously in relation to the most intrusive powers, namely interception, we are enhancing the authorisation procedure by introducing the double lock of having the Judicial Commissioner looking at a warrant as well as the Secretary of State. There are also the oversight provisions which are provided at various levels, obviously also by the new Investigatory Powers Commissioner, and then there are also requirements where data is being retained by companies. There are various requirements in relation to the various acts that those companies need to abide by, such as the Data Protection Act and the Privacy and Electronic Communication Regulations of 2003, which require data to be held by the companies in a secure fashion, so securely. And of course we do introduce the offence in relation to misuse of data that is being retained by the companies.
There remains a concern as well, though, that communications data definitions, and Dr. Murison has touched on this, remain still relatively vague. For example, Clause 1951 says, and I quote, "Data includes any information which is not data." Now, what does that mean?
Yes, and I completely understand people raising an eyebrow or two at that particular sentence, which I did when I read it myself. And its attempt to, and I'm happy to look at the wording, but it is an attempt to do something very simple. For a lot of people, if you talk about data, they tend to think only about computer stuff, electronic records. Actually, what we're saying is that when we use the term data in the bill, it can cover, for example, paper records as well. So it's an attempt to be helpful, which in its language I think has not been.